Hello, and thank you for choosing the Legacy Lawyers as your source of information. We know this might be a difficult time you are going through, but we are here to educate you and help you through the process. Please stay tuned for our question and answer portion.
Good morning, Erin.
Good morning, David. How's your day going so far?
Very well, thanks.
Good. Okay, so for the past few weeks, we've gone over trusts and trust disputes, and today's the last day of our trust scenarios. So today's scenario is, once my father became incapacitated, my stepmother became trustee of his trust. Everyone in the family was fine with it until she put my father in a care facility and started taking lavish vacations without him. Is there anything we can do to protect the trust?
Well, if your father is incapacitated, you can file a petition even though the trust is I'm assuming under its terms, revocable, meaning it could change, and therefore the concerned children's interests in the trust aren't exactly solidified. So you can file a petition to submit the court, to present the trust to the court for court supervision, in which periodic accountings are rendered. That gives a level of protection for dad that his assets are being prudently managed during his lifetime. Through the process, you can ask the court to appoint what's called a guardian ad litem. That is usually an attorney, and is someone appointed by the court to represent what are in dad's best interests. And that person may say, I see a reasonable cause for concern, and I'm going to insist that this trust be placed under court supervision or some sort of separation of assets, and to make sure that dad's care will be taken care of financially for the future. If you look at it more broadly and say, what can I do to protect the trust, into what can I do to protect dad? Well, we have an issue in which the children have serious objection to dad being in a care facility. And this is not just a mere desire that doesn't have any respect for whatever the assets are or the facts. So let's just say that there is a less restrictive alternative that is reasonably feasible. Let's just say that there is sufficient wealth for dad to live at home, which he has expressed a desire to live at home, and he can well afford it, or the marital community can well afford it. And that doesn't mean that wife has to stay home and look over dad. I mean, we're talking about a care manager. The children can file a petition as interested parties to place dad under conservatorship, in which one of the children would be the decision maker for dad's personal needs of where he gets to live and how his care is being managed. The wife definitely has a higher level of priority to be appointed as the spouse. However, if the children can demonstrate that the appointment of the wife is not in dad's best interest, then they can prevail. Also, if dad has the ability to express a intelligible preference that the children are a much better choice to be his conservator, well, the court will take that into consideration and actually favor the children, and the onus will be on the wife to demonstrate that it's not in dad's best interest that the children be appointed. And the children can then decide where dad gets to live. They can decide how his care is being managed, and dad will receive a court-appointed attorney and sometimes also a guardian. And the guardian will have a say as to how the funds are to be managed. So if mom and, or I guess in this situation, dad and stepmom have $100,000 to their name, and all of a sudden she's going to start taking $10,000 cruises, and the guardian ad litem sees that, or the children see that through some means, they can ask for court intervention to stop that, because the use of those funds, which are being used in a manner that will deplete the estate, so that dad will actually end up not being in the facility by being broke in the future, can be stopped. So the probate court is a court in which they assume protection over people who are not there, or people who are not able to make their own decisions in a very broad sense. So you go through probate court for someone who's deceased, so they're not there to make their decisions. You appoint an executor or trustee. And also the probate court handles conservatorships, which are proceedings in which a decision maker is named and appointed to manage the affairs of someone who can't manage them on their own. So the concerned children would definitely seek some sort of court supervision over the affairs of dad, both in the trust as well as in the conservatorship proceeding.
Okay, thank you very much.
You're welcome.
And if you guys have any additional questions, feel free to email us at smm@thelegacylawyers.com. Have a great day.